Hi, my name is Wesley and I'm a director from Velden-Duffey attorneys in Rustenburg. Companies, more often than not, comprise a number of people as directors and shareholders, and this may lead to conflicting personalities and disputes. However, not all disputes or friction result in a court application. The purpose of this video is to try to explain to you when you'll be entitled to approach the court for relief. As I said, not each and every conduct requires or entitles you to approach the court. The court will hear your application in circumstances where either the act or omission of a company has a result which is oppressive or unfair to you, or the business of the company is being conducted in such a way which is oppressive or unfairly prejudices your rights, and finally, when the act or conduct of a director or executive officer of the company is oppressive or has an unfair result. You may ask yourself, what entails oppressive conduct? Well, the courts have defined oppressive conduct to be conduct which is unjust, harsh, or burdensome. Conduct which also evidences a visible departure from the norms of fair dealing would also constitute oppressive conduct for purpose of bringing an application to court. I have to stress that the facts of each case will determine whether or not you're entitled to approach the court. Further to this, what is required in order for you to approach the court is that the conduct itself is unfair and the result of such conduct is also unfair. It is quite possible that conduct may be at first glance unfair but will not lead to unfair or oppressive results, in which instance you would not be entitled to approach the court for relief. Motive is irrelevant for purposes of bringing an application to court. Whilst an improper motive may suggest that the conduct is oppressive or unfairly prejudicial, it does not determine the issue finally. The court has enormous powers in such an application. The court can do almost anything that it deems just in the circumstances. This could entail removing a director or interdicting the conduct which is being complained of. There's also circumstances where the various shareholders fight with one another and cannot continue with their business relationship any further. In this instance, the court may well order the exchange of shares, which would be a buyout of one shareholder's shares from the other shareholder, and that way they can part ways. As I said earlier, whether or not you're entitled to approach the court is a factual question which entails a detailed consultation. You're welcome to contact my offices or send me an email, the details of which appear to my left, and we can see how we can be of some assistance to you.